Chancellor of McClean and Thornhill KC, Parthead.
Yes.
My ladies, in the Supreme Court in America, they allow advocates half an hour for to develop their best points, so I've got plenty of time this morning. I've got the following.
Principally are. I once went to the Southern District of New York, where they had the same system in the federal court. The red light came on after 10 minutes. And the doyen of the New York Insurance Bar, who was a man called Mr. Tom Newman, was making submissions. And the presiding judge just said, "Mr. Newman, ignore the light, you just carry on as long as you want to." It's really interesting.
Lord, I'm so sorry, one shouldn't take her. My learned friend can knock this off my time, but I was in the Supreme Court being led by Sir Sidney Kentridge on his 90th birthday. And he'd given me very strict instructions, so with lots of counsel. There's a time for him. And I had to tug his gown at 1 hour 50 minutes. And at 1 hour 45 minutes, I thought, this is so good. I'm not going to tug the gown. And he just carried on relentlessly, not relentlessly, beautifully and immaculately. And Lord Newberger said at the end how what a treat it had been to listen to. So these things happen.
With that by way of introduction, can I tell you what course I'm going to adopt? First, you've got on your desk, I hope, 3 things. One is the note, which I promised you.
It's very helpful. Thank you very much.
The second is 2 passages from the transcript. Can I just deal with what they are and what they deal with?
Yeah.
The first is a passage from the transcript day 7. This relates to the question which my Lady Justice Carr asked yesterday at page 111, line 22, as to whether Mr. Thornhill was asked why he didn't put an opinion in, and the intervention which Mr. Adam made in response at pages 140 and 141 yesterday. And he was asked about 2 things. He was asked about an opinion from another member of the bar, from Mr. Goodfellow, and you see the bottom of page 93, he was shown the part of the opinion saying, "I provide this opinion solely for the benefit of the persons referred to above," and he was asked at 94, "That's likely to assist the reader in terms of knowing what's the purpose and who can rely on it. Not an expert, I mean, how going through paragraph 3, I really don't know. I can see it might assist. Whether it would be a complete job, I don't know." Then he was shown a letter from some Californian lawyers, and the material parts are at the bottom of page line 22. Please be advised, line 24, please be advised you may provide a copy of such opinion to Andrew Thornhill, Tax Counsel Partnership. Insofar as Mr. Thornhill is not our client, he may review the letter, but he's not authorised to rely on it. Do you see that? Yes, I see that. Question, you could have included that wording in your opinions in the IM, couldn't you? I could have done, yes, I could have done. Indeed, perhaps I should have done, but the fact is I was still relying on the separate advice being obtained. So that's the relevant evidence.
That's him saying, isn't it? I didn't think I needed to have a disclaimer because I thought they were all going to rely on their own advice.
It is. I'm at the moment simply on the factual question which my lady asked me yesterday. I made my submissions yesterday and I don't resile from them, that actually what he thought about his reasons for doing something are not actually relevant to the issue.
Okay, so that's day 7.
But having had an interchange about what the evidence was and so forth, then you can see what it is.
And we've now got day 8 as well.
Yes, now day 8, this is in relation to a point which we were discussing yesterday and which we're going to come back to, which is the question of trade and business and the effect of section 42. And what you get is a series of acceptances from Mr. Thornhill. First at lines 4 to 7, the concepts of trade and business are not coterminous. Something could be a business without being a trade. Answer yes at page 10. Business is a wider concept than trade, isn't it? Answer yes, it is at 12. That distinction was in place at the time you wrote your advice, and he says it was much earlier than the early 1990s. And then he's shown the Finance Act 1992, which is the provision that we looked at the bottom at line 22, referring to a trade or business which consists of the exploitation. He agrees that it does. The question, top of the page, trade or business, quite clear that Parliament didn't think that exploitation of films was necessarily inherently a trading activity. Answer, yes, if you're using the term exploitation of films, that's absolutely correct. Then there's some questions about Ensign and Lupton, and there's an acceptance at the bottom of the page that commercial purpose is a requirement for trading. That's at lines 23 and 24. And then the point is that in order to establish whether or not you have a trading transaction, you have to look at the facts, don't you? Answer, you have to identify the transaction, yes. And then you see as it were, the debate being entered. You can't assume that simply because the transaction you're concerned with is making, exploiting a film, it's automatically a trade, can you? And the answer, I think, if you find a person who's both making and exploiting a film, generally speaking, it would be a trade. I mean, except there are some methods of exploiting films which are not trading. But if you're actually the person making the film, you then go on to exploit it by distributing it, then I'd say that's a trade, end of story. And then the debate continues. Now, that's there in relation to, as it were, what the evidence
And the next bit's important, isn't it?
I
In
mean,
the
he's
context
basically
of what we were
saying,
saying.
He maintained the position.
What my lady was saying to an extent yesterday.
Yes, absolutely, Mother. I'm just looking at this question. I want to come back to this, but it's relevant in the context of the submissions I'm going to make. Now, can I tell you the course I propose to adopt this morning? I propose, first of all, to take you briefly through the third document, which is the summary note, which you asked for. It is intended to put in more comprehensible form than I obviously managed yesterday afternoon, the submissions that I was making yesterday afternoon. And actually, on reading the transcript, I realised that there were a couple of points where I'm afraid I'd missed the import of what the court was putting to me, which was, I'm sure, my fault. But I want to deal with that. I'm hoping that I will do that in less than 20 minutes.
Yeah.
I then want to change course in order to get the ship safely home and deal with UCTA quite briefly, because it comes on from the end of that, and deal with 10 minutes. Then I propose to use half an hour finishing off in relation to the errors. And if I've got time at the end, I will spend no more than 5 minutes dealing with Mr. Miller and the various provisions that are made in relation to that. Now, in total, I've got half a day left. I'm hoping to finish by the mid-morning adjournment. If I go quarter of an hour or so, it'll come out of my reply. So that's the course I'm proposing to adopt. Could I invite you, please, to take the summary note of propositions? We've recorded what the court asked me, the point being made about duty between about 2:30 and 3:15, and we've identified what we understand that to be, which is a request for the key propositions between 104 line 4 and page 145 line 11, just so that you know what that is. That's from when I stopped going through the documents and went into the argument until I went into the duty. Now, the starting point is that those submissions start by reference to paragraph 24 of our skeleton argument, which is core bundle 2, page 395. Before that, in points that I had already sought to make in the course of going through the documents, I was making these points in the context of the key propositions which we put out at paragraph 1. Scots took responsibility of the IM and expressly stated the information didn't omit anything like to import the import of the case, front page of the IM. Just on one small point, which one sees coming up later. Information and advice. My submission, pretty unhelpful in general terms, but particularly unhelpful in the context of a document called an information memorandum and in the context of the statutory system. You have got statements being made. There may be statements of fact, there may be statements of opinion, but they are still statements. You've seen from the statutory regime that it's plain that they can be statements of fact and statements of opinion.
Yep.
Plainly, what you require to verify statements of fact and statements of opinion will differ, but in essence, to verify statements of opinion, you need to be appropriately qualified, you need to give proper consideration, you need to sign off in relation to it. And so I say that information and advice here means the contents of the memorandum fairly read, and the statements within it, whether, as it were, you'd characterise them in the light of BBL or anything else as being advice or anything else. Second, investors were told of Mr. Thornhill's opinions, which are available from Scots, and of the consistency of the financial summary with his advice. That depends upon the proper construction of the passage which my lady, Lady Justice Carr, took me to, and my lord, the Chancellor, took me to. We say it's explicit. If it's not explicit, it's implicit. But that's what I mean by that. And then, if any doubt had been expressed in his opinions or trading, it would have to have been reflected in the information memorandum. And we say it would have to be reflected at least in the key risks and the financial summary. And the final point, there is no explanation anywhere in the information memorandum, as it were, of the granularity of the tests for trading or the breakdown or what's required or on a commercial basis and so forth. The assumption is that this is going to, the LLP is going to qualify for the appropriate tax reliefs and then be available. Now, that was the background to the submissions that I was making. If you could just look at 24, I'd started making those submissions, and my lady...
This is your skeleton argument.
My skeleton argument, 395, my lord.
Hang on a second. So that's core bundle 2.
Core bundle 2, tab 24.
Hang on a second.
No. Pretty shortly after pretty shortly after I'd started making my submissions, my lady, Lady Justice Carr, asked a question, and fairly shortly after the Chancellor made a question. And looking at them, they were plainly focusing on subparagraph C. Now, just to be clear, what we say this could have been, what would have been needed, is a clear and express statement to the IM and Thornhill's opinions, and I accepted that could be and or Thornhill's opinions in order for him to be released. Clear and express a statement that neither the sponsor nor Thornhill took any responsibility, and then by a clear and identification, one of the key risks for investors was accordingly the absence of the tax benefits. Now, in my submission, looking at that, I can see how that is a little bit misleading. It's misleading for this reason. It's plainly not enough to know in general terms that there is a theoretical risk. Everyone knows that there's a theoretical risk in relation to tax. Equally, in my submission, it's plain that telling someone in general terms to consult their own advisors on a whole range of issues is not equivalent to issuing a disclaimer in respect of specific information that is offered with what we say is an express assumption of responsibility. And can I just make plain, if one were to say that simply saying take your own advice was enough to disclaim responsibility, it would have enormous consequences, not just in the field of investments, but elsewhere. Imagine that you are buying a antiquity, and you know that there is a risk that although the antiquity is said to be 2,000 years old, it is a modern forgery. And you go to a reputable dealer, there will be implied terms of your contract with him that he has an honest and reasonable belief that the item accords with its description and so forth. But suppose he also says to you, and what's more, I've consulted Professor Snooks. And Professor Snooks is the leading expert in relation to antiquities. And you can have a copy of his opinion, and he knows that you've got a copy of his opinion, you'll be given a copy of his opinion for the purposes of the sale. And he says that it is 2,000 years old. Now, in my submission, being told in the course of the contract of sale, take your own advice, would not negative the assumption of responsibility. What would be needed would be for the contract of sale to say either no responsibility is taken for Professor Snooks' opinion, or alternatively for Professor Snooks to say no one can rely on my opinion. But the whole reason why in the context of sale that isn't done is that what is being intended to be done with this is to make the sale. You're trying to induce the sale. One of the most famous aphorisms in sales management is kill the doubt, make the sale. We're a million miles away from a NRAM sort of circumstance. You're in a circumstance where Thornhill has set up, advised in relation to the setting up of the scheme, given an opinion, knows that his opinion, first of all, is going to be provided, that's what he's told, but certainly is available to investors, approves the event of the IM. In those circumstances, he knows that the whole purpose of this is to persuade people to buy this investment. So that's, we say, the context.
Can I just ask whether this overlaps with the brief discussion yesterday we had about partial reliance, which
Yes.
may be a different way of saying the same
Well,
thing? But just the question, and it's an open one, is your position that it's sufficient to have what could be called, to create a duty of care based on an assumption of responsibility for there to be partial reliance? So that the adapted NRAM question would be, was it reasonably foreseeable that investors would at least partially rely on Mr. Thornhill's advice, and was it reasonably foreseeable by Mr. Thornhill that investors would at least partially rely, and we have the judge's findings at paragraph 88 in this regard, knew that they were likely to take comfort from, etc., etc. Is, as a matter of law, partial reliance sufficient
Well, the way I put it,
to create a duty of care based on assumption of responsibility?
I would say that partial reliance in this context is reliance. There are a whole series of different circumstances in which you can rely on different advisors, either in relation to different things or the same thing.
Well,
So-
there is, there's plenty of authority in the context of reliance itself, that partial reliance is sufficient. I mean,
Quite.
I've got in mind Edgington and Fitzmaurice
Quite,
and,
yeah.
and all
Quite.
those line of cases. I mean, those are fraudulent disrep, but the same principle applies in negligent disrep. But is there any authority you can point to which says, in the context of whether or not there's a duty, that partial reliance would be sufficient?
Well,
That I think is
No, it's a bad phrase, my bad
Yes.
phrase, partial and non-exclusive reliance.
yeah, non-exclusive reliance.
No, I can't point to non-exclusive reliance being sufficient, but I would say it's the other way around in this. You're looking here for which is something which negatives the fact that you're intending, the whole purpose of this commercial transaction is to make the sale. And in those circumstances, to get out of there being a duty of care, it can't be enough to say you've got an IFA as well, or you've got a solicitor. And just to just take that through and just put one thought further on. Suppose that you have someone, Mr. Miller, who's a cautious individual, decides that he's paying a lot of money in and decides he wants his own solicitor to look at him. As we shall see, he sends a copy of the opinion itself to the solicitor from Stevens and Bolton. There is a difference between what the advisor will do if he is told you can't rely on this, compared with, we've got here an opinion from leading counsel. One only needs to know there's confirmation bias, first of all. Secondly, actually implicitly there is something different in the nature of the instructions. You're not doing a grounds up requirement. One's only got to imagine the circumstances when people genuinely want to get an independent advice. What they normally do is not give you the advice which they've already obtained, with which they're hoping now they sometimes then give it to you there afterwards, but what they're trying to do is get a wholly independent view on it. And thirdly, you've got the whole point about the difference in the nature and statute. But fourthly and fundamentally, the fact...
Sorry, the third point, oh, yes. The
For-
nature of the statute, what do you mean by
Not,
that?
not a nature and stature of
Nature and stature.
the person.
Looking at the line there.
Sorry.
It's my fault.
Nature and stature.
It's my slurred words.
But that is Mr. Thornhill.
Yes.
Sorry, fourthly, you said.
Well, what I was going to say is this. Imagine a situation And for these purposes, this is fair, because there's a separate point which the Chancellor makes, is it fair to say that Mr. Thornhill has actually taken advice, is responsible given the terms of the information memorandum and so forth. But suppose the information memorandum had said in terms, Mr. Thornhill confirms that there is no doubt and he sees no problem, in other words. In other words, there is a direct quotation within the information memorandum of what he says, and he accepts, he does responsibility.
Yeah, and for what it's worth, I'm having thought about that a bit more overnight. I'm not sure the point I was making necessarily is a good one in this sense, that I think, looking at what you say in paragraph 1C of your note, it's the point, isn't it, that actually it may not have quoted the opinion, but the fact is that if Mr. Thorne had qualified his advice to any appreciable extent, they would have had to say something.
That's my,
at least in the risk factors section.
That's my point, my lord.
Yeah.
But all I'm saying at the moment is, for the present purposes, one can test the position in terms of there being no doubt whatsoever as to what the advice is, and the fact that, and then imagine that it says you're advised to take your own advice, and you go off and see Mr. Snooks from Stevens and Bolton in Guildford, and you give him the Silk's opinion, and he says, yeah, I think the Silk's right. Does that really mean that you're then not entitled to rely on the Silk above it? That's the fundamental point. And in my submission, you only need to state the proposition to see that it's not the case. Then, we're now in paragraph 2. I've really dealt with B. C is quite important. The task of looking at the words which are relied on, and I don't want to go back to them, but the words I mean are the words in the information memorandum and the words in the subscription documents, has to be undertaken in the context of the relevant words which would otherwise impose liability on Mr. Thornhill. And we say that in the light of that, you'd have needed an express disclaimer of the sort that we've identified in paragraph 24, and where we've quoted what was actually said in Brown and Innovator. Then we've got the point, which I know you have on board, that the context of the risk factors refers to the lack of advanced clearance, which itself is effectively referring back to what I say is the next best thing for Thornhill's advice. And then, there's a point I've made already, knowledge of the existence of a theoretical risk doesn't destroy an entitlement to rely on the evaluation of that risk. I mean, just to make that point, I know I can lose this trial, but I sue my barrister for telling me that I was likely to win. Then you've got the point, and actually on reflection, if I'd had a little bit more time, I might have left this out at H, because actually the fact that he said it is probably irrelevant. It's probably a jury point, but the fact is he could have put it in objectively. Yeah.
Well, the opportunity is relevant on the
The opportunity is irrelevant.
The
Actually,
thought
what he's
process-
cross-examined
the thought
about
process
doesn't matter. Then the other major topic, which was dealt with yesterday, is to the legal test, and effectively how NRAM fits into the previous and existing jurisprudence. Can I just make a few points about this? The law, particularly the law of negligence, develops incrementally. We know that the law of negligence normally goes forwards, although sometimes it engages reverse gear. See Murphy and Brentwood. Whether in the light of Grenfell Tower, Murphy and Brentwood was such a good engagement of reverse gear is perhaps a subject which may be revisited in due course, but that's by the way. Normally it goes forward.
Yeah.
The reason I started off with Denning and Bridge in Caparo, and the whole nature and background of this, is that we actually say that the law in relation to statements made by experts in the context of sales is really quite far advanced, and had developed subject to the Court of Appeal in Candle and Crane Christmas overruling things like McCall and Wilson and saying that Lever and Gould and so forth found them. But that was all swept away by the time you got to 1961 on Headley and Byrne. And certainly by Caparo, we say that the relevant law was clear because of what I've shown you in the passage and so forth. So that's all of the context in which you're looking at it. NRAM we do say paragraph 19, I don't resile from saying that actually, if you want a modern statement of the legal test for assumption of responsibility, paragraph 19 of NRAM is as good as any other. But that does not have any reference to independent inquiries. It's simply got the two aspects of reasonableness involved in it. And when we then come to the question of what is meant by independent inquiry, that's going to depend upon the factual situation. This is our little c. And the point I was making yesterday was that in NRAM, you only had to look at the files. This was a lender. He knew how much he'd lent. He knew how much was going to be paid off. And then the question of separate or independent advice begs the question of what this advice is expected to be directed for, about what, and from who. And we would say that an IFA or a solicitor who's asked to look at it will be expected to rely on the statements made by the respondents unless you can't do so in clear terms. Just imagine an IFA who's presented on the one hand with Mr. Thornhill's opinion or the information memorandum in its existing form, and he looks at it and says, well, you've got a theoretical risk, but they've been off to the chap in tax chambers. He seems to be quite happy to let you rely on it. That obviously involves being with me on the questions of construction that I've looked at. Now imagine the situation where you have an opinion which says this cannot be relied on. The first thing the IFA says is, look, they've sent you this, but you can't rely on this. You've got absolutely no recourse whatsoever. That's the first piece of advice which will be given in different terms. And that fundamentally is the legerdemain which is being played here. And so we then say that without independent inquiry of Lord Oliver can only mean inquiries to the very point on which reliance would otherwise placed, which is the meaning of the adjective independent. And then we've made a separate point in that. And we'll also, I hope that's helpful in seeking to make sense of what I was trying to say yesterday.
The judge had to deal with a whole raft of additional points on duty.
He did.
Including, for example, one thought that crosses one's mind in the context of your final submissions just now is access to documents and things like that. But that none of that plays a part in your submissions.
No,
No, I'm not inviting you to. I'm just saying
I'm
the judge
not,
did have, and no doubt Mr. Adam is going to make something the fresh way it's being cast. But yes.
Yeah, well, one of the the fact of the matter is that Mr. Thornhill has got access to and indeed has been involved in with the setting up of the whole transaction. He's got an intimate knowledge in relation to it. I can't say that an advisor looking at this couldn't have said, right, I want to see this, I want to see that, I want to see the other, and so forth. But more fundamentally, this is already in the context of someone who's already gone over the ground in relation to it. And so to say, oh, well, they could have done this, they could have done that, they could have done the other, doesn't really help. It's in no way analogous, in my submission, to a situation where all the lender has to do is look at his file. Can I then deal with the Unfair Contract Terms Act? Can I draw your attention to paragraph 34 of our skeleton argument, which is on page 399. Now, sorry.
Yeah.
The judge deals with the Unfair Contract Terms Act in his judgment, and if one goes in particular to what the judge is saying at paragraph 160, it starts at paragraph 158, page 104. And at this point, I am looking at what is said at 169 and 170. And that is in the context of what is said in 163 at the top of 106. There is no disclaimer of responsibility as such in this case at all. My conclusion that no duty was owed is not based on a disclaimer of responsibility, but on the fact that in all the circumstances, including the terms of the IM and subscription agreement, it was not reasonable to expect investors to rely on Mr. Thornhill's advice without independent inquiry. The question whether a disclaimer of responsibility was sufficiently clear and stated does not arise. If UCTA were engaged at all in this case, it's because the warranties are construed as notices, but for which Mr. Thornhill would owe a duty to the claimants. Specifically, if UCTA were engaged, it would be because without the warranties that the claimants are relied on to their own advisors, Mr. Thornhill will have owed a duty. The relevant question is not therefore whether the warranties clearly conveyed to the claimants that Mr. Thornhill disclaimed responsibility, whether they completely conveyed that investors' subscription was made in circumstances where they promised they relied on their own independent advice on tax matters. In my judgment, the warranties in the subscription agreement and checklist were entirely clear in this respect. Now, obviously, if that's wrong, that all falls away so far as reasoning is concerned. But then he is referred to the judgment of this court in First Tower Trustees against CDS Stores Limited. And you have that authority in tab 5 of the authorities bundle. It's a recent decision of this court. And
Tab
it's
5 or file 5?
Sorry, file 5, tab 36. I'm sorry, my lord.
Yeah.
And what this was a case where a lease had been granted over certain warehouse premises. And there was, as the judge found, a misrepresentation pre-contract. And there was a clause in the lease, and you will find the clause in the lease. It was 5.8 at page 1307. It's paragraph 14. The tenant acknowledges that this lease has not been entered into in reliance, whether wholly or partly, or on any statement or representation made by or on behalf of the landlord. So that was what was at issue. The defendants relied, as one sees from the head note, on their exclusion clause and concluded that their liability was limited to the extent of the trust fund. The deputy judge allowed the counterclaim, holding the exclusion clause was unreasonable for the purposes of Section 3 of the 1967 Act and Section 11 of the Unfair Contract Terms Act. There was an appeal, and the finding was that a clause in the lease which simply stated the lease had not been entered into reliance wholly on partly of representation was a contract term which would, apart from Section 3.1 of the Misrepresentation Act, have had the effect of excluding liability for misrepresentation and was subject to the test of reasonableness. That whether such a clause passed the test was an evaluative judgment, etc. If you can then look at paragraph 41, which is where the matter is dealt with, first of all, by Lord Justice Lewison. What he says, apart from Section 3.1, does it exclude any liability which the landlords had reason by representation made by them before the contract was made? He says, apart from authority, it can only be answered by inquiring what position would have been if clause 5.8 had not been there. Absent clause 5.8, I consider the position is clear. The landlords would have been liable for misrepresentation. The only reason why they may not be is the existence of clause 5.8. On the face of it, therefore, clause 5.8 is a contract term which excludes liability for misrepresentation. And to similar effect is what is said by Lord Justice Leggett at paragraphs 110 to 111, right at the end of his judgment.
Paragraphs or pages?
Sorry, I keep on getting this wrong. Paragraphs, my lady.
110.
Paragraphs 110 is right at the end of the judgment. Now, the judge, first of all, held that he was entitled to depart from, well, he first of all found that this was obiter. Secondly, he found, and this is paragraph 169 on page 106 of the judgment, that in the light of what was said in Ram, and in paragraph 100, following Ram and the other cases which I referred, the test for liability depends on whether it was reasonable for the claimant to have relied on what the representative or advisor said, and whether the representative or advisor should reasonably have foreseen they would do so without independent inquiry. That is a question which has to be answered by reference to all the circumstances. Well, with respect to the judge, the idea that there is now a wholesale change in the law, so that there is the equivalent of a statute, and it is said that the law is that this, that the question is whether or not it can be relied on without independent inquiry is simply wrong. That's our first point, which we make in our skeleton argument. And we say that with respect to him, the statements in any event were binding on him. It would be a matter for this court to decide what, if anything, the effect of Naram was. But in any event, we say that the statements were unquestionably correct, looking at the matter from a point of logic. Now, in that event, we say the unfair contract terms did apply, and we rely upon the conclusions which were set out. He found they would have denied liability for that which is expressly accepted. Now, he found that the relevant terms were clear. Our submission is that it is plain that they were not clear. That's little two, that I accept is important. And three, that when you then have a look at what the consequences are, and you look at the minimum investment, which is gross funding of 102,000, the loan of 79,050, the cost of obtaining advice and so forth, and the fact that you would have expected the advice to cover exactly the same ground as was being covered, then the Unfair Contract Terms Act applied. Now, I've taken that as something of a canter because inherent is the application at all is several factors which I've already sought to persuade your lordships you don't need to go towards, but just so that it is there and you understand how it fits into the argument. Subject to anything that the court has to ask me, I now propose to move back to duty. Sorry, I propose to move back to breach and pick up where I got to yesterday afternoon. Now, the first bit, I'm afraid, is I just do need to show you one other bit of Mr. Justice Millett's judgment in first instance in Ensign, and this is in support of the proposition that you need to look at all the facts, even on the basis of what Mr. Justice Millett was saying, and I should have taken you to it at the same time as I was dealing with this judgment in first instance. It's Authorities Bundle 1, tab 11, and it's page 272 of the Authorities Bundle. And the relevant passage, relevant passage starts, it's bundle 270, internal page 1232 is where the whole passage starts. Now what the judge is doing here is, just below C, many aspects of the law have been usefully summarised by Sir Nicholas Brown Wilkinson, the recent case of overseas containers. I take the law to be as follows. And he then goes through and makes a series of propositions. But for these purposes, can we just go to the 9th proposition, which is on page 272. Accordingly, in my judgment, and adopting the words of Lord Simon of Glaisdale and Thompson versus Gurnville Securities, the question is whether, in the light of all relevant circumstances, and I emphasise those words, all relevant circumstances, the transaction is capable of being fairly regarded as a transaction in the nature of trade, albeit one intended to secure a fiscal advantage, or even conditioned in its form by such intention, or is incapable of being fairly so regarded, but is in truth a mere device to secure a fiscal advantage, albeit one given the trappings normally associated with trading transactions. So in Mr. Justice Millett's judgment, in the passage summarising the trade, he is emphasising the need to look at all relevant circumstances. Now, my lady, Lady Justice Simler, asked me yesterday as to the continuing relevance of badges of trade and
Not generally. I was just putting it in the context of this particular transaction. I fully accept badges of trade may be relevant in many contexts. I was struggling in the context of the acquisition of licenses and the exploitation of those licenses in distributing.
Can I just tell you where I'm going, and then, if I may, tell you where in the context of this field, there are authorities which, Samarkand and so forth, which postdate Mr. Thornhill's advice, which downplay the badges of trade, and my lady, I'm sure, is familiar with those.
Yeah.
Those weren't in existence at the time that Mr. Thornhill advised. That's the first point. The second point is that at the time that Mr. Thornhill gave his advice, badges of trade were, to use a colloquialism, all over the Inland Revenue manuals and were stated to be looked at as such. Thirdly, in relation to the features which we say would have caused an eyebrow to be raised, we say, if you look at 7 of the 9 badges of trade, a competent silk would have been saying, this looks a bit odd against what we know to be the factual foundation. And for these purposes, can I make it plain that the factual matters upon which I'm relying are those found by the judge? I'm not seeking to reopen what he said about that. And those matters, we say, should have led to 2 key conclusions.
Can you just give me a note of where I'll find the matters that you say?
Yes, you can. But it's in our skeleton argument, although it's buried in a footnote. And it's one of the occasions when one realises that footnotes may save space in order to comply with court regulations. But
Well, they're an
maybe
old
less
trick.
sorry?
They're an old trick.
Well,
Is it footnote 22 on page?
there are 2 relevant footnotes, my lady.
Yeah.
The first relevant footnote is 22.
Yeah.
But that footnote are the features which we say particularly would have been apposite to causing doubt as to the separate commercial basis test.
Right.
And they overlap with what we say about the badges of trade, which is footnote 26 on page 404.
Yeah.
So that's where that's our crib list.
That's fine.
But just me being a somewhat slower ship in this particular convoy than certain members of the court, can I just show you how, as it were, we get there in relation to the underlying material. Now we have put in. Sorry, just to start off before we get there. You have already seen in the information memorandum the reference to the to the practice of the Inland Revenue. And if one sorry, I'm going to yes, I found it. If one can just look at a few of the relevant. Can we start, please, by the note which was handed up to the judge in closing, which is in supplemental file 2 at page 251. And it is at tab 23. It's the first. Now, this
So
note,
tab,
tab 23, my lord, page 251. Supplementary bundle 2,
One.
tab 23.
Bundle 1.
My learned friend tells me it's bundle 1.
Bundle 2 in mine.
Yeah.
no, they're all in a rather, supplementary bundle is rather oddly
Well, there we are.
laid out.
Starts
I'm
at
not
23
complaining, it
without-
just wasn't quite what I thought it was going to be.
Starts
I've got
at
it.
23.
Sorry, it looks.
These are the authorities on the need to consider all the facts.
It looks as if bundle gremlins have attacked. I'm sorry about that. These authorities of themselves are simply, frankly, well-known statements that you need to consider all the facts, and they're gathered there together, and I don't take you through them. But in addition, there are references here to 3 Inland Revenue manuals which are in existence at the relevant time.
Yep.
And can I just identify where these 3 manuals are to be found?
Yeah.
IMI 21 is at tab 30 of the same bundle. IMA 123 is at tab 31 of this same bundle. And IMI 24A is at tab 33. Sorry, IM 124, I'm told that I've shown my ignorance. But they're tabs 30, tabs 31 and tab 33.
They were
for
on
the
our
3.
reading list, weren't they?
They were.
Yeah, they were.
Now, in addition, that if you go please to, well, if you look, for example, at tab 33.
Yeah.
This is the Inland Revenue talking in published guidance to its own inspectors. And it tells them at 390, you should be consistent in your approach to transactions which may be trading transactions, irrespective of whether they lead to a profit or loss. However, you should examine critically claims that a trade exists where that claim may have been made to get relief that is only available to traders, such as loss relief or retirement relief, and it goes on. So the Inland Revenue are telling its own inspectors, you need to look carefully at this particular issue. And then, if one then looks at the importance of badges of trade, if one goes to IM 125 at tab 36, you see the revenue saying each case where the meaning of trade is an issue must be decided on its own facts. The approach of the appeal commissioners and the courts over the years has been to examine the facts and look for the presence or absence of common features or characteristics of trade. These are the open inverted commas badges of trade, which have been identified as case law as developed before the courts. The report of the Royal Commission on the Taxation of Profits and Income in 1955 reviewed that case law and identified 6 badges. Since then, the concept has been refined and enlarged, and IM 125A gives a summary of a present classification. A modern review of the badges is Marston against Morton 59 tax cases. Now, the next bit in the next tab is 37, which is IM 125, which is the 125A, which is what's referred to immediately before. Could I ask you to keep that open whilst also taking out Marston and Morton, which is the in Authorities Bundle 1 at tab 10, and which is a decision of the Vice Chancellor, Sir Nicholas Brown Wilkinson. And he deals with the badges of trade, starting at the bottom of page 255 of the bundle numbering, 1347 of the intrinsic numbering.
Sorry, give me the page number again.
255 of the bundle, 1347 of the report.
Thank you.
And the introduction, just below letter H, if I can pick it up, against the background, one turns to consider what the position is so far as the law on this matter is concerned. Like the commissioners, I've been treated to an extensive survey of the authorities. But as far as I can see, there's only one point which is a matter of law is clear, namely that a single one-off transaction can be an adventure in the nature of trade. Beyond that, I find it impossible to find any single statement of law which is applicable to all cases and all circumstances. I've been taken through the cases, invited to compare the facts, in some cases with the facts in the case here before me. I fear the commissioners may have become as confused by that process as I did. The purpose of authority is to find principle, not to seek analogy on the facts. And then, after that introduction, he starts at just above little d with a series of what are referred to as the badges of trade, subsequently being 9 factors. The first one, the transaction in law being a one-off transaction, and the 9th one, on page 257, being did the item purchased either provide enjoyment, etc. Now, unfortunately, the 9 factors which are identified in the Inland Revenue Manual overlap with, but are not identical to Sir Nicholas Brown Wilkinson's, and they're in a different order. I mean, that probably
Doesn't matter, does it? I mean, they're not principles of law. These are just factors that one looks for. They might be relevant in one transaction and not in another. The weight might be different depending on the nature of the transaction, or they may not be there at all.
Absolutely, my lady. Absolutely. But what my fundamental point about this is this. The revenue is telling its inspectors to look at these matters and so forth. It's also telling them that this is all a question of overall fact and degree, etc., and you look at them. But then you come and look at what these factors are, and in my submission, you start getting warning signals for the reasons that we identify in tab 26. And just looking at Sir Nicholas Brown Wilkinson's list, the second factor is the transaction in question in some way related to the trade which the taxpayer otherwise carries on. So the taxpayer here is the LLP. There is no connection between the activity and any trade the taxpayer other carried on. The next one is
because it's just started, or
it's just started.
The
It's the only thing.
LLP has been created to trade in exploiting licenses and distribution of films.
The example that Sir Nicholas gives is classic, isn't it? If you go on, a one-off purchase of silver cutlery by a general dealer is much more likely to be a trade transaction than such a purchase by a retired colonel. I mean, it's a common sense point, that this one.
They're all common sense points.
Yes, I mean, I was just going to make this point. My lady, I am not saying, and we do not ever say, that there is some golden bullet which you have said, look at that, this can't possibly trade. That's completely inconsistent. And what I'm doing for present purposes is highlighting points which need to be considered by
But I don't even see how that is a point in the context of this case. This is an LLP that started out to trade in the exploitation of film distribution rights.
Well, my lady, with respect to trade, it rather begs the question. I mean, it sets out to exploit films, but can I?
Is the transaction in some way related to the trade?
Milady, do you mind if I'm...
I don't mind, I'm sorry, I'm
No,
being
no,
difficult. I am being difficult and I'll... Sorry.
The overall point I'm making in relation to this is I'm not saying there's one point. Your ladyship is saying, well, that doesn't appear to be a problem to me. In a sense, I'm saying, fine, let's have a look at a few of the other
So
ones.
two is one of the ones you rely on.
Yes.
Go on.
Then number 4 is the trade, the way the purported trade was not carried on in a way typical of such a trade. And going back to what Sir Nicholas Brown Wilkinson says, in some cases attention has been paid to the way in which the transaction was carried through. Was it carried out through in a way typical in a trade of a commodity of that nature? And that has implications also for the commercial basis test. Then the next one is the lack of borrowing. That's fine.
On that last point, Mr. Thornhill did ask himself that question, didn't he?
Well, yes, but the trouble of...
Is this a trade that's carried on in this way in the commercial world? It may be in the context of was it commercial or uncommercial, but it's the same question.
Well, it's a similar question, but the trouble about that is that he then says, oh, we don't, effectively, he says, we don't need to look at actually what the commercial terms are. Well, that makes nonsense of the whole thing.
I follow that.
And that's what we say about that. I mean, coming back to the fact, simply to say, well, I'm told there are some other people who do something similar, doesn't, in my submission, get you anywhere. Can I just identify the factors and then stand back? 5. Sorry, the next one is the lack of borrowing, which is Sir Nicholas Brown Wilkinson's 5. What was the source of finance of the transaction? If the money was borrowed, that is some pointer towards an intention to buy the item with a view to resell in the short term, a fair pointer towards trade. Nothing of that nature here. By way of contrast, what you're actually doing is getting money in from investors to invest. Then 6, lack of significant work done by the LLP. That is factor 6. Was the item which was purchased resold as it stood, or was work done it or relating it for the purposes of resale? Obviously you need to change that, but we say effectively the LLP is doing nothing to these. Then the distribution rights not being broken down into sellable lots, but highly likely to be sold under the one call option. If you look at that 7 was the item purchased, resold in one lot as it was bought, as it broken down into sellable lots. That's the call option. And then you've got the intention not to resell in the near future, which is 8, what were the purchaser's intentions as to resale at the time of purchase? If there was an intention to hold the object indefinitely, albeit with intention to make a capital profit, that's a pointer towards a pure investment as opposed to a trading deal. On the other hand, if before the contract, that's a very strong pointer towards a trading deal. And then lastly, there's the fact that you've got income from the field, from the films, which is 9. Did the item purchased either provide enjoyment for the purchaser, for example, a picture, or pride of possession, or produce income pending resale? If it did, that may indicate an intention to buy either for personal satisfaction or to invest for income yield, rather than to deal merely for the purpose of making a profit on the turn. So what we say about all of these is that when you look at them, and I fully accept that, as it were, looking at these and applying them isn't the easiest matter, but in a sense, what's being said in the information memorandum, we've looked at these and there's no problem with any of them. They raise immediate questions. The commercial basis overlaps with this because if one looks at the factors, and this is footnote 22, which we've taken directly from the judge's findings of fact in 285. 285 is quite a lengthy paragraph with sub-paragraphs where he makes findings in relation to what he says was going on. What we say are uncommercial and not reflective of what commercial traders seriously interested in profit would do. Warner Brothers' wide right to substitute film, lack of control over additional pictures. Warner Brothers can simply decide to provide the additional pictures. The LLP being guaranteed to see the marketing strategy only 14 days before theatrical release. lacking ultimate control over that strategy, absence of contractual control over excess P&A cost, the way that commercial comparators would have much lower guarantees and thus a completely different allocation of risk, the presence and highly likely exercise of a call option to allow investors to engage in tax arbitrage, the significant curtailment of any material upside together with long delays, and the lack of any chance of a material loss. I'm just pointing there. A venture in the nature of trade involves normally risk. What is being told to these investors is, look, tax advantages are there, you don't make a loss, you have a lottery ticket chance of getting even more gain, but you don't make a loss. That doesn't look like a trade. Now, all of those factors, we say, when looked at from the point of view of the current inland revenue guidance and the need to look at all the facts, would have screamed out for analysis. Can I deal directly with the point which was made by my lady yesterday about the situation or the possibly analogy between Warner Brothers carrying on the distribution and the LLP carrying on the distribution? Well, first of all, and my lady may be against me on this, given what she said, Warner Brothers are engaged in distribution of numerous films all over the place. This is, as it were, a one-off partial transaction. They haven't got anything else in the LLP by way of distribution of trade. And it's not at all apparent that anyone within the LLP would have had any previous or particular film experience that they would bring to the table. A studio, by way of contrast to whom it's sub-distributed, would have such experience. Second, way the purported trade was carried on, not typical of such a trade, pointer against trade. That's also overlaps with Livingston, which we dealt with yesterday. Lack of borrowing, we've dealt with that. Obviously, Warners would fund themselves in a different way. The lack of significant work being done by the LLP, it was the sub-distributors who would actually carry out the marketing of the distribution. That's judgment paragraph 15. And it was also the sub-distributors who created the budgeting and marketing materials. See judgment paragraph 17. And since the sub-distributors were affiliates of studios, they presumably were doing significant works. Intention not to resell, again, we say significant pointer, and actually importantly, income. If one is looking at this in relation to a trade, the number of occasions when you hold something for 12 years getting an income out of it and are found to be trading is, we submit, really rather few and far between.
Sorry, I didn't hear that. Is really?
Number of occasions when you hold something for 12 years, getting an income out of it is really rather few and between when you're trading.
Rarely found to be trading.
Now, collectively, these gave rise to real doubts as to trading. Yes, Mr. Winter makes the point that the very difficulty of application of some of these points makes certainty in relation to them rather, or the question of trading, rather unusual. The next point is the point we make at judgment, sorry, at paragraph 48 of our skeleton argument, page 405. And this comes down to the question of subjective motive. Now, the subjective motive of a taxpayer in entering into a transaction is not generally relevant to the question of whether they are or are not trading. But in our submission, we say that the correct legal test is that where a transaction is equivocal, motive is still relevant. In other words, when you're looking at whether this is trading and the matter is in the balance, motive is still relevant.
And that was the position you said as a matter of law at the time.
Yes. And my lady still is. So collectively, what we say is that Mr. Thornhill went off on a frolic of his own without justification. He didn't start from first principles. He signed off in our submission on an information memorandum which not only dealt with the law, but also inland revenue practice. And bluntly, given that the purpose of this transaction was tax avoidance, not tax deferral, but tax avoidance, given the instructions that the revenue had given to their inspectors, to say that the matter was free from doubt, or there was no doubt, was an extraordinary thing to do. Bertrand Russell said the whole problem with the world is that fools and fanatics are always so certain of themselves and wiser people so full of doubts. Now, in terms of where we are in relation to this, I do ask each member of the court to consider how a reasonably competent tax silk could have expressed his view on the law in the light of what I have shown you in the terms that he did. And if he couldn't, he was negligent. And it's not a question of him failing to give a risk warning. It's a question of him having failed properly to advise. And that had direct consequences, as my lord observed in his our case, for the terms of the information memorandum.
Does it matter when you're considering that question? I can see that if Mr. Thornhill was advising a person who came to him and said, I'm thinking of investing in this scheme devised by Scots, and I want to know whether you think it's a safe bet. I can see that that's a question that we need to consider, and I can see how you put your case. And I'm just asking, does it matter that he wasn't giving that advice? What he was doing is that he, together with Scots, had devised a scheme in which the LLP would be inserted into a transaction that involved the making, distribution and exploitation of films and film rights. And he was advising Scots, which had their own expertise, about the particular issues that Scots asked. Does that matter is all I'm asking in a very neutral and open way.
Not in the circumstances of this case, my lady.
Because
Because if you look at his instructions at page 327, I'm looking at the first set of instructions, Core Bundle 2, tab 327.
So page,
327.
yeah.
What he's told in the first paragraph is that since August 2002. He's been asked to opine on a number of issues and questions. This was done in a number of letters, instructions, counsel. The purpose of this document is to collate all the questions and issues raised by Scott in relation to the above with a view to seeking a written opinion. We've sought to update the questions, and even before that, we know that he had,
Page 326, isn't it?
yes,
The letter was intended to be included as part of the information memorandum.
yes, he knows in this context that the purpose of his advice is to assist in the sale.
Yeah.
And in that context, he set up the scheme, He's given advice in relation to the setting up of the scheme. And just parenthesis at that point, I mean, he knows at that point, if he says this isn't going to work, that's the end of it, and so forth. But he's now got to the point where the preparation is being done for this being sold. So the equivalent is the seller of the antiquities coming along to Professor Snooks and saying, look, I'm thinking of selling this object. I need an opinion which I'm going to be able to give to the buyer. Or more simply, actually, the seller of grain saying to inspector, I need an opinion from you on the quality of the grain which I'm going to be giving, and so forth. Now, one could take different analogies, but the fundamental point is that at the point he's giving this opinion, he doesn't think that it's simply for Scots and no one else.
That's the point, isn't it? You say, if you look at 326 and 327 together, he was aware that Scots were going to use the opinion to sell the scheme to potential investors.
Absolutely.
And therefore, it was incumbent upon him to give his opinion, which would include, as it were, a warts and all analysis. If that's what the reasonably competent tax consultant would have done.
Yes.
That's
Or alternatively, and
so same, as it were, the same opinion or the same approach to giving the opinion as if he'd been instructed directly by Mr. Middle, whoever.
Yes.
Give me an opinion on this scheme.
yes, madam. Can I just turn my back and just see? I'm told to see whether or not I can ask for 5 minutes in order that I can have 1 or 2 points adequately explained to me and see whether I need to eat into my time for the reply.
Well, it's probably time to have a break anyway, Mr. Stewart. So we say 5 minutes, please.
2 points. First, very short. I said something about the lack of availability of expertise and so forth. The point I was seeking to make was that the members of the LLP were not experienced. This wasn't, for example, a group of insurance brokers gathering along to do a trade as insurance brokers or something of that nature.
No.
Secondly, one point which is in our submission of importance and which I've only really touched on, but I do just want to make properly, is that at paragraph 46 of our skeleton arguments, and for these purposes, could you also please have, that's core bundle, page 404, paragraph 406, and could you also have, please, the judgment at core bundle 1, page 131.
Yeah.
Now, at paragraph 201 of the judgment on page 114, Lord Templeman, the judge cites from the speech of Lord Templeman.
Sorry, 141, 114.
114, paragraph 201. The judge cites from the speech of Lord Templeman in Ensign Tankers. And in identifying trading purpose in that case, as the judge states, at the end he says, whereas in the present case, a trading transaction can plainly be identified, the Victory Partnership expended capital in the making and exploitation of film. This was a trading transaction, which was not a sham, and could have resulted in either a profit or a loss. Then, by contrast, look at his findings of fact in 131 and 132. Little 4, lack of chance of material profit. A, the LLP's profit on the basis of the minimum payment guarantee was 11% of the amount.
Sorry, I'm lost, it's my fault.
131, my lady. Judgment, page 131.
Thank you.
It's para 285, I think.
Paragraph 285 of the 4. LLP's profit on the basis of the minimum payment guarantee was 11% of the amount committed over the life of the LLP. The maximum further profit theoretically available to the LLP under the waterfalls in the MSA and DA was 161 million, on the assumption the LLP had committed the full 330 million envisaged in the IM, plus the possibility of a further 1% of excess profits in the event of a real blockbuster. Whether the films could in practice produce income to ensure that enough flowed through the waterfalls to enable that theoretical profit to be realised was not a matter on which a reasonably competent tax QC could be expected to opine. He or she could rely on their instructions on the work of a suitable expert in the field. I'll just point out there wasn't such an expert here in relation to it. But nevertheless, these limitations on the likely profit of the LLP meant that its prospects of any material upside were significantly curtailed because the bulk of the profits would be distributed to Warner Brothers and sub-distributors. Moreover, the receipt of much of those profits by the LLP was delayed for a considerable period. In the event the call option was exercised, then on the basis of the minimum guaranteed amount, the LLP would make a small loss. There remains the possibility the amounts paid under the call option would be higher if one of the more films turned out to be a blockbuster, but the amount paid was the higher of the minimum guaranteed amount and the fair value of the future income stream. The potential downside for the LLP if the films failed was either completely protected in the event the call option was not exercised, or mostly protected if the call option was exercised. So there was no chance of making a material loss. So this is a trading venture where your upside risk is severely curtailed, as you see, and there is no chance of material loss. Doesn't look like trading.
Well, the judge deals with this at 302, doesn't he? Because he accepts that if you were looking at it in hindsight today, then it doesn't look like trading. But he says on the basis of Ensign, it was.
But the trouble about that is I've just taken you.
Well, you've taken us to one passage. We need to look at the whole of what Lord Templeman said about this.
My lord, I accept that, but the ensign is the get out of jail card which is sought to be used, and the key passage cited by the judge is that one, i.e. the trading venture. And in my submission,
Well, there's 202 as well, he cites.
my lady has.
Yes, okay. But
And
you said
my
that's
lady,
that's the main bit he starts with.
coming back to that, no doubt. Yeah. Those with apologies for overrunning are my submissions. Is there any further matters?
Thank you very much.
Thank you very much. Yes.
My lord, my lady, like my learned friend, I propose to start with duty, but I'm going to follow a slightly different course. If I could just explain how I propose to develop my submissions. First, I'm going to start at a general level and examine the overall contours of the map which the authorities have drawn to approach this issue, which is whether a professional engaged by one person should owe duty to people who are not their clients. And then secondly, I'm going to go to the specific level and descend into the details of this case. But before I do either of those things, let me set out my stall. I'm going to give you the case on duty in a nutshell, or what I think people younger than I am call an elevator pitch. Scots were selling these tax schemes, and Mr. Thornhill was advising Scots. Everyone knew that he was advising Scots. On controlled terms, he agreed to allow Scots to provide the advice which he had given to them to other people if they asked for it. So the overall shape of this case is one in which there is a deal going on, buy-sell. The parties are at arm's length, but the seller has agreed to allow the buyer to see its own legal advice. Now, in that situation, the common law has reached a clear position, one, that it has to be objectively reasonable for the non-client to rely on his counterparty's lawyer without independent inquiry, and two, it has to be objectively foreseeable to the lawyer that that is what they would do. Now, the judge held that neither of these propositions could be established by the claimants in the circumstances of this case, and he was obviously right. There are three core documents. There's the information memorandum, there's the subscription agreement, and there's the checklist. Those contain what I called a moment ago the controlled terms on which Mr. Thornhill agreed that his advice could be shown to people who asked for it. On any objective reading, those documents, individually and together, convey an unmistakable message from Scots. You can see our tax advice from Mr. Thornhill, but you are not intended to rely on it as if it was advice to you. You've got to take your own advice. You can read our advice, you can give it to your advisors, you can ask them if it's right, you can ask them what the risks are, you can ask them if they think Mr. Thornhill's missed things. You can subject it to whatever critical scrutiny you like, and you can see what your own advisors make of it. We think it's jolly good, but get your own advice. It's your advisor's advice to you, which you can rely on. It is not Mr. Thornhill's advice to us, good as we think it is. Now, that is the message of the core documents, but it's not just the core documents, because all the surrounding circumstances of this case point in the same direction. So you've got the nature of the scheme. It's incredibly complex and ultra commercial. You've got the nature of the target market, who are ultra wealthy and ultra sophisticated. You've got the regulatory environment, which has two important facets. First is the complete lack of any statutory protection. You're outside FSMA. And secondly, a regulatory strict requirement for independent skilled advice. You've got the ready availability in the market to any investor for skilled independent tax advice. Now, all these points, which are outside the documents, these are extraneous factors, etc. But they have one direction of travel. And that direction of travel is that it was not, on any objective assessment, reasonable for investors to rely on the advice which had been taken by the promoter of the scheme they were buying into, and nor was it objectively foreseeable to Mr. Thornhill that as an advisor to that promoter, the investors would rely on his advice to the promoter as if it was advice to them. Now, my lord, my ladies, none of this is, if I may say so, the least bit surprising. That this is an inevitable, in fact, I would say it's a conventional reflection of the fact that Scots and the potential investors were very much at arm's length in a buy-sell transaction. Buyers can only reasonably expect to be able to rely on advice which they know has been taken by the seller if the circumstances of it being provided to them clearly indicate that that was what was intended. And not only were no such indications given them, in fact, the document said the precise opposite, and the surrounding circumstances all serve to negate that as a purpose. So that's the essence of the case duty. And I'm now going to turn to the general legal principles which are in play here. Now, the general issue of lawyers owing duties to third parties was examined in some detail by the Court of Appeal, this court, in January this year, in a case we haven't looked at yet, called Ashraf. So if we could have authorities 5, this is where I'm place to start.
Yeah.
And it's at 10:57.
Let me just clear the decks afterwards.
Yes, now I'm in the same state.
Authorities 5.
At some point, somebody's going to design a jumbo-sized lectern for barristers, and they're going to clean up. So it's authorities 5, tab 37, please.
Oh, this is Ashraf, yes.
This is Ashraf.
Yes.
And the facts of Ashraf are not. Have you got it yet? Sorry.
Yeah.
The facts of Ashraf aren't significant for our purposes, but broadly, they turned on whether it was arguable that a solicitor who was acting for a lending bank owed a duty to the true proprietor of registered land when undertaking activities which were related to the registration of title. So specifically it's about solicitors, but the reasoning applies generally. And obviously, because it was an appeal from a summary judgment, it's about arguability rather than being determinative. But it has a very valuable overall survey of the scene by Lord Justice Nugent. And if we go straight to 52, please, which on page 1348. He says, I'm going to start with the general principles. And his first proposition in paragraph 53 it is well established that the general rule is a solicitor acting on behalf of his client owes a duty of care only to his client. And if I may flip that and put it in the negative, that means they do not owe any duties to people who are not their clients. And that is the default position. And it doesn't matter, as he goes on to say, it doesn't matter if it's conveyancing or wills or litigation or any other situation. As a general rule, lawyers only owe duties to their clients and not to other people. And at 55, over the page, he says that the reason for this is a very simple one, which is that the lawyer has agreed to provide services to the client, but has not agreed to provide services to the third party. And he goes on in 55, that's in the first 3 lines, but he then talks about conflicts, and this has some resonance in this case, I'll just pause on this. So it's sometimes said that one of the reasons why a solicitor does not owe duties is because their interests diverge from those of his client. That may very often be the case, and is a good illustration of practical difficulties. But I do not myself think this is the main reason why no such duty is owed. In my view, the main reason is because the solicitor acting for a seller is not providing a service to the buyer. And this is so, even if it is in the buyer's interests, as much for the sellers, for the transaction to be completed competently. And he says, draws a parallel with litigation, and then says, in each case, the solicitor has not agreed to act for the other parties, has not agreed to provide a service to them, and it follows he owes them no obligation to perform his services with care and skill. Now, that resonates with, and I just, before I go to the judgment, I'll just show you that he picks that up again in paragraph 68, which we just turn on. That is at page 1353 of the bundle. And he's dealing with the matters relied on by the claimant. And so the first matter relied on is the bank's interest, the true proprietor's interest were aligned, as the bank should have no interest in registering.
Hang on a moment, where are you?
I'm so sorry. Page 1353,
Yeah,
paragraph 68.
68.
68. I hope the bundle gremlins haven't got us on a no. It's the second
Their
paragraph.
interests
on
were
the page.
aligned, as the bank should have had no, yeah, got you.
Yeah, and he says so they relied on the fact that the interests were the same as showing that there should be a duty, and Lord Justice Nugie says, as I've already said, I do not think that the fact the third party's interest and the client's interests are aligned on a particular point is enough to generate a duty of care.
That's important wording, enough to generate.
Exactly, not enough to generate. Now, as I said, that resonates with the judge's approach, and I'm.
It may be a factor, well, second doesn't stand in the way, self-evidently. If the interests are aligned, it could be that's a factor in favour of, even if it's not enough to generate.
Yes, and let me show you how the judge reasoned on this. So just so you know how this arises.
It depends how you define the interest that's being talked about, doesn't it?
Yes.
Because in one sense, the interests of Scots and of the investors are aligned. Are aligned because they all want the scheme to work. But in another very real sense, they are at arm's length because they're buyer and seller.
Exactly, saying that was the judge's approach, and can I just show you that? But just so you know how it arose, Mr. Thornhill's case was that the interests of Scots and the investors were not aligned, and the investors said that there was no conflict as to whether it worked because they're both interested in it working in a general sense, and the judge accepted the investor's case on this. So if we look at paragraph 90. So that's core 1, tab 10, page 92. There he said leading counsel then for the investors place significance on the fact to accept in relation to the issues on which he advised there was no conflict of interest. They both had an interest in the tax benefits being achieved for different reasons, he said. And then if you go on to 118, he then says that it doesn't matter. And he says, although I've accepted there was an identity of interest as between Scots and investors in connection with the issues on which Mr. Thornhill was asked to advise, it is nevertheless the case that Scots were selling and the investors were buying into the schemes such that they were on opposite sides of a transaction. So in response to the same submission that was made in this case as made in Ashraf, that look, that they've got an identity of interest, so that points towards a duty. He says, well, yes, they have got an identity of interest, but more important is the fact that they're on opposite sides, which is the point that Lord Justice Nugie was making. And if you look back at 74 in the judgment, that's at page 87, he develops here the point about them being on opposite sides of the transaction. There's 74, paragraph 74, page 87. It says, the question arises in this case in circumstances where Mr. Thornhill's client, to whom he undoubtedly owed a duty of care, was on the opposite side of the transaction to each of the claimants as potential investors. So that said, the client was the sponsor, the relationship between Scots and the investors was one of buyer and seller, the schemes were being sold by Scots to the investors, they prepared the IM with a view to attracting investors to the schemes on any objective analysis of the transaction, although the subject matter of the transaction was an investment in a potentially long-term scheme. Scots were nevertheless selling participations in the scheme to investors. In no sense, therefore, was any investor a client of Mr. Thornhill. That, I would suggest, is exactly right. His conclusory aspect of the reasoning at 118, that it doesn't matter, is based squarely on this analysis of 74, which is clearly correct. And what he's saying is, look, there may be an identity of interest, but that doesn't matter. It matters less than the fact that they're clearly not his clients and they're clearly on the other side of the transaction. Now, that analysis, I mean, the paragraph 74 analysis, I would suggest, is irresistibly right. And that has his conclusion that that is the more important facet on duty has now received some specific support in Ashraf. It's not about conflict, says Lord Justice Newby. It's about whether you are serving two masters or whether you could reasonably be perceived as serving two masters. And as I will explain when I come on to the specifics, that is simply not a credible proposition in this case. So, going back to Ashraf, Lord Justice Nugent set out first the general rule: lawyers don't owe duties to people who are not their clients.
Yeah.
Then he set out the general rationale for that rule, because you're not doing anything for them. And then he categorises exceptions to that rule. And he helpfully puts them into three groups. And he starts out at 56. And the first group is the White and Jones class of cases. That's not this case. The second group at 57 is where the solicitor for one party makes representations to the other party in which the other party relies. Here the general principle that no duty of care is owed usually applies, and that's very much this case, and that's what we're going to have to scrutinise. As he says over the page at 1350, the rest of paragraph 57 says that's governed by NRAM. Having acted myself many times for, well, not many times, several times for NRAM, I can assure my learned friend that they pronounce it NRAM and not NRAM. I didn't mind his exotic accent.
I got that right, yes.
But he says that this is the NRAM principle, and obviously we're going to have to spend some time on that. And then he says his third category, and that's at 59, again, there are only three categories. His third category is where the lawyer has stepped outside the usual role. They've stepped outside being lawyer to their own client, and they've taken up a role which, as you can see in the quotes from Al-Kandari, is characterised as being independent of both parties or an agent of both. And that's the last paragraph of the quotation from Lord Justice Bingham, as he then was, over the page at 1351. Now, sorry, it's in the first full paragraph at the top of 1351 of the quotation, 4 lines down. The third line assumes a different role, either independent of both parties or as agent of both.
Yeah.
That's the key. And the rest of this judgment, Lord Justice Nugent calls this the Al-Kandari principle. Now,
Lord Justice Nugent wasn't here really looking, and I'm sure you're going to come on and meet the appellant submissions that, of course, the basics, the basic professional negligence fair is perhaps uncontentious, and the NRAM test is also non-contentious, but certainly Lord Justice Nugent didn't have in mind the sort of prospectus, lending your name to a prospectus, offering up your advice within that context type situation.
Yes, I mean, obviously all cases ultimately descend to their specifics. I'm currently trying to give you the general picture, because I think it is helpful to see how the law has analysed and categorised this particular type of case. When I come to the specifics and the idea that there's something in these documents which could indicate to a buyer that they were entitled to rely on the seller's advice, I'm going to be showing you that that's not
Are
right.
there any authorities, Mr. Adam, accountants, valuers, whose opinions have been referred to in IMs? Or is there any
Yeah, I mean,
authority
there's plenty
on
of-
liability of advisors who are,
Yeah, I mean, the one that immediately springs to mind is Peach Publishing and Slater, which we'll look at.
Yeah.
So there you've got an accountant who is acting for a seller. The buyer is sitting with them in a completion meeting going, tell me that these accounts are right. I want to know that these accounts are right. In the end, I'm rather spoiling the case, but in the end, the accountant says, yes, they're right. Mr. Justice Reimer, I think it was, says duty of care. Court of Appeal says no duty of care, essentially because you knew they were acting for the seller. It's caveat emptor. You don't just rely on what you're told. I mean,
so
I'm giving you again
All right, thank you very much.
the postage stamp. But Peach Publishing and Slater is a clear example. It's not a prospectus case, but it's a selling case. And the account, I mean, there are lots of cases on accountants which,
well, I'm just trying to think. I mean,
well, there's Morgan Crucible, there's Electra and KPMG, there's, you know, the claimants cited quite a few of those in closing below, but gave the judge look, this
if
just
there's
isn't
anything helpful on this opening and the general state of the law and assumptions of responsibility by
It's like a long
professionals to,
like a long roll call from
Old
something in the very
friends.
dim and distant past.
old friends.
I once did as a junior, I did a huge amount of accountants negligence cases, but
Yeah.
I can't. I was trying to think as my lady was speaking whether I could think of anything
Close.
directly on the point. I couldn't.
No, because ultimately it all turns on particular circumstances in which the advice from the professional, and I think it's more usually accountants because you know they're
Well, the
people
facts
looking-
could be different, couldn't they?
but the
Because in that
principles could be
example,
helpful.
the accountant could say, well, don't worry, even though I'm acting for X, you can rely on my advice.
Yes, quite. I mean, look, we'll be looking at BCCI,
Yep.
which is a case like that, and actually, Lord Justice Neal's checklist in that is extremely helpful. So that's a selling case. It may not be done through the formal medium of an IM, but that doesn't make a difference in this case because the statutory regime isn't engaged. This isn't a FISMA case. So it is actually quite often in a buy-sell context, and I'll take you through that actually as we go.
Yeah.
So now, the point about the Al-Kandari principle, and I have to say something about this because my own friend has shown signs of trying to adopt this. So if I can put it in this way, he's been flirting with the idea, but I don't think he's yet nerved himself up to ask it onto the dance floor. But I am going to cover it because the point that's made is that he's saying, well, Mr. Thornhill he'd stepped outside being a normal barrister. At one point we actually had the submission yesterday that he was not acting as a barrister. He was doing something so extreme. Now, that case is, that principle, those principles in the Al-Kandari case, the Al-Kandari principles, Lord Justice Nugent calls it, is really not in play here. It's only about where the lawyer is taking on a joint role for the client and the third party. And in that situation, the third party is by definition reliant on the lawyer because the lawyer is now doing something specifically for them. So the NRAM questions of reasonable reliance, was it reasonable to rely, was it reasonably foreseeable that you would rely, just don't arise.
I don't understand Mr. Stewart to be engaging the third category
Well,
in Ashraf at all. I think it's all, as I understood it, it's about the second category.
Though there were submissions to the effect that Mr. Thornhill wasn't acting in the normal capacity of a barrister.
and it's in the skeleton argument too.
Yes.
Well, there was the analogy with Andrews and Hopkinson,
Yes,
which we picked up.
I'll be
Mr.
dealing with
Stewart
that.
on.
My lady Justice Carr, I think, has another question.
No.
No?
Anyway, it's a question of interpretation. Anyway,
With Andrews and Hopkinson, those sorts of cases, I mean, it's not a solicitor's negligence case or anything of that kind, or a barrister's negligence case, but those are cases where there is a representation that is clearly made by the defendant to the claimant
Yes.
and relied on.
Yes, I mean, as I'll show you when we look at the good little.
So it's, one's in different territory.
Yeah.
Completely different territory.
Yes, the only insight one is going to get from Andrews and Hopkinson is about the importance of intermediate advice in independent inquiry. I mean, it is a good little bus, but it's trundling out of the garage in this particular case is not necessarily appropriate. But I'll do a minute on it or two when I get there. So, and I'll just to show that this as is said against Mr. Thornhill, who has been described, if I may say so slightly impolitely, as a second-hand car salesman yesterday. That the submission that's made in Malone Friend's skeleton argument is that he was not acting as an advising barrister in any ordinary sense. So that is his skeleton argument at core 224.
Paragraph 24.
It's paragraph 12.
Paragraph.
C, 12C. Mr. Thornhill was not acting as an advising barrister in any ordinary sense. He was doing two distinct things, advising his client. I mean, I assume that they accept that was within the ordinary sense of being an advising barrister. That should be common ground. But then, secondly, he assisted in the sales process by allowing his analysis of the scheme and how it worked to be summarised and offered by way of information on which reliance was very likely to be placed. Now, I take issue with a number of those contentions, but and when I get to the argument that reliance was very likely to be placed on Mr. Thornhill's advice to Scott, so I'll cover that in the scheme documents, and that's a larger topic. But just let me explain the position in relation to the other contention, that he wasn't acting in any way as an ordinary advising barrister by allowing his advice to Scots to be shown to prospective investors. That the case there seems to be that he was somehow acting as part of the sales force. This is abnormal. This is not what barristers do. Now, could we have the judgment, please? Paragraph 142. Which is on page 102. Yes, I'm sorry, my lady, we have finished with
We
that.
finished with that.
No, I'm afraid we haven't finished with authorities yet.
No, we finished with Ashraf.
We've gone with Ashraf. So we have the judgment. Page 102 of Core 1, page 104, paragraph 142 of the judgment. And this was the contention which was then advanced directly by reference to Al-Kandari, that Mr. Thornhill had stepped outside. And the suggestion was made then as now that agreeing to allow his opinion to be seen by potential investors was somehow equivalent to stepping outside the normal partisan role of a lawyer. Now, first of all, the judges had no truck with this, as you can see, and nor should you. Mr. Thornhill was advising on a scheme. That is completely normal. He gave his genuine views on the scheme. There's never been any case advanced that he was tailoring his advice to suit what his client wanted to hear. Never been suggested that he was doing a sales pitch. And so Mr. Stewart's characterisation of him yesterday as a car salesman was absolutely unfounded, as well as being impolite. Mr. Thornhill's own remuneration was not in any way dependent on the success of the scheme. He was just giving his view. And giving your opinion is not selling.
I had always understood this part of the submission, and hence perhaps the crossed wires, not to be, he wasn't acting as a barrister advising, but it was just not a traditional advising your client and then assuming some sort of additional responsibility to a third party. It just not a normal duty of care situation. Am I wrong about that? Isn't that the thrust of what's being said? Because when you look at the overall context, this wasn't your, if I can use it this way, bog standard instruction in terms of duty.
Bog standard for the tax bar, advising on schemes of this kind.
Yes, absolutely. But
Your Ladyship has exactly the point, my Lady Justice Simler. In fact, while we're there, let's look at the way this is pleaded. Could we have core tab 14, please? I think that's in core 2.
It's called to.
And at the particulars of claim, paragraphs 6 to 8, which is on page 213. So as Mr. Thornhill would have been well aware, film finance schemes were brought to market following receipt of advice from leading tax counsel with specialist expertise. Fundamental to the creation and marketing of such schemes that a legal opinion will be obtained, supporting and endorsing the tax implications of tax benefits. The purpose of instructing leading tax counsels to obtain advice as whether tax benefits envisaged by the promoter would be available. If it was decided to proceed with marketing the scheme, leading tax counsel's advice would be routinely referred to and or reproduced and or reflected in the IM. Now, far from therefore this being something abnormal or unusual or not bog standard, the claimant's own case was that this was a routine event for leading tax counsel. And in fact, that was reasonably common ground. Just for your note, I don't think we need to take up time looking at it. Mr. Thornhill generally accepted these propositions. That's in paragraph 9 of his defence, core tab 15, page 310, just for the transcript. And then the evidence in the case showed that this was absolutely so, and the judge held it. Could we please look at the judgment at paragraph 350? It starts at page 142. And this is in the context of causation. And the judge said, there's insufficient evidence from which I could draw the conclusion that if they hadn't liked Mr. Thornhill's advice, they wouldn't have been able to find another in the text QC. And then he says, to the extent that there was any evidence in the case relevant to this point, it was to the effect that there were many film partnerships in the market at the time, and these had the backing of senior tax counsel. He refers to an article in the Tax Official Review, which we'll have a look at later on today. So if the claimants are right about the stance in their skeleton argument, at paragraph 12c, and hinted at from time to time by my learned friend, that Mr. Thornhill had stepped outside the usual role of a silk by allowing a promoter to use his name and make his advice available on terms, then a whole class of activity by leading tax counsel suddenly should be characterised as selling the schemes, being in the sales force, and thus not acting as normal barristers. And that would be a surprising result.
So just so I'm clear, so you have a chance, Mr. Adam, when appropriate, to deal with it. The point is not about the activity being carried out being anything out of the ordinary at all. It's in terms of analysing the duty of care. The situation is not as straightforward as it is in a totally classic client barrister situation. That was all I was trying to say.
Yes, no, of course.
So that's just so I'm clear. It's a slightly different point that I think is what is being driven at.
There are two aspects to it. One is that you're advising.
Yeah.
That's bog standard. We all do it all the time. The thing that's not standard outside, well, actually, I have no idea. Maybe all sorts of other bits of the profession in which opinions are shown. I mean, take the circumstances of this case. It's backed by a commercial litigation fund. At some point, they've seen a merit advice from someone, and may not have been addressed to them.
Exactly.
It was presumably given to them to induce them to fund the claim.
Exactly.
The bolt-on is the knowledge that the advice which has been given to the client is going to be shown to somebody else.
Exactly.
And then it all becomes about the terms on which it's shown.
Exactly. It all becomes more complicated.
Yes, well, it is an added complication, certainly. And of course, if
The point that was made, it's the point that's made, I think, in your defence, that you just showed us in paragraph 9 of the defence responding or accepting the point in paragraph 8 of the particular claim, makes the critical point that the information memorandum and the advice, tax advice referred to in it, was not prepared for the purposes of advising the investors.
yes, that's
And
absolutely
that's the
right.
critical point, isn't it?
It is. It's provided for.
I mean, Mr. Stewart was on occasions a bit dismissive about this, described it as a sales pitch or whatever you describe it as. It was, the information memorandum was seeking to sell something.
Yes,
It was not seeking to advise them.
exactly. And when you start at the tax avoidance scheme table, you need to bring with you a long spoon, because they are selling to you. And that's the context, of course, in which the advice is then supplied. But even if the claimants were right about this, even if they were right that Mr. Thornhill was doing something abnormal and had become involved in selling alongside Scott, so he's now like them. But I mean, of course, that carries with it, I just think your Lordship's point underlies, it carries with it the seeds of its own destruction. Because if you are part of a sales team and everybody can see that, then obviously you are not acting for both sides. You're not abandoning your I'm acting for a client role and becoming the outcome barrier. I'm now a neutral person that everybody can rely on, which is what my learned friend needs. He needs Mr. Thornhill to be presented in this deal as the kind of independent valuer or expert that everybody can rely on. But if he's part of the sales force, then ex hypothesi, he's not a neutral figure. So the argument doesn't work even on its own terms. In Ashraf, it was arguable. We need to look at that. But a case where this does arise quite clearly is the Peach Publishing case, which I referred to a moment ago. And that is in Authorities 2, tab 19. If we start with the head note, I'll just outline the facts briefly before I turn to the relevant passages. So this is a decision of this court in relation to a sale of shares. The Slaters, the defendants, were the accountants of the sellers, and the buyer was very interested in the management accounts. And you can see from the head note that at the buyer's request, the buyer is L, and her name currently escapes me, I'm just hunting for it. Was it Mrs. Land? Mrs. Land was interested in buying. Peach was incorporated by her for the purpose, and at her request, Slaters produced management accounts for the company she was interested in buying. So you can see now the foundations for the duty argument, because the buyer says to the seller's accountant, I want management accounts, please produce them for me. And the accountant does so. And then carrying on, you can see that the buyer wanted a warranty of the accounts. Slaters wouldn't give the certificate, and that was the state of play going into the third paragraph of the head note, which is the completion duty. And as you can see, in the end, Mrs. Land extracted from Slaters a representation that the management accounts were essentially reliable, subject to not having been audited. And you can see that just flipping on to page 532. At the very top is the judge's findings of fact on what passed at the meeting. And right at the top it says, it follows that I find that Mr. Slater did make a statement to Mrs. Land to the effect that the accounts were right, which I find conveyed to her that they were essentially reliable, subject to the qualification of not being audited. So you've got a direct oral representation from the seller's accountant to the buyer about the accounts, which were his subject of expertise. And if we go back to the head note at 520, there's a warranty which is then given. It says including a suitable warranty by the shareholders in line with the statement that the accountant had made. With that run-up, we can now look at the principles.
So these allegedly actionable representation was something to the effect that the accounts were right?
Yes, the accounts are right.
Yeah.
And if you look at page 540, you can see the rival arguments. Mr. Justice Reimer had held that the duty of care was owed in making the statement. And the Court of Appeal disagreed. And at the top of 540, you can see the dispute. So Slater's, that's the accountants, contend the judge was wrong. They say the only reason she wanted a statement from them was to get a warranty. It submitted that any assumption of responsibility as to accuracy was to his client and not to the buyer. And then the buyer contends that the judge was right. They emphasise that the accountant made the statement against the background she'd been pressing for reliable accounts. He produced them. So he had produced the accounts, that is, and he was the sole provider of information about the target company to her advisors, Ernst & Young. So she had EY acting for her. And then Lord Justice Morris says, I accept the submissions of Slater's, and then he starts to explain his reasoning. Now, I just want to pick up 3 points because they're of general application for rejecting the assumption of responsibility here. The first is at page 540, just underneath where we were. And the first thing he relies on, he said, look, this is a sale. It's a sale and purchase. Everybody's got their own advisors, including solicitors and accountants. Mrs. Land was professionally qualified and experienced businesswoman. The maxim caveat emptor remains as applicable in such a transaction as ever. One party does not just rely on what he is told by the opposite party or his advisor. Now, that has resonance here. Because obviously, if a vendor makes it's not a universal blanket rule that you just can't rely on anything. Because if a vendor makes a representation in the course of a sale and purchase, you may be entitled to rely on it. It all depends on the terms in which it's conveyed. But what Lord Justice Morris says is, look, hang on, this is an arm's length transaction. The default assumption is caveat emptor. You take your own advice. You don't just rely on the other guy's advice. And nobody added, after Mr. Slater's oral misrepresentation, the accounts are right. However, you're advised to consult your own accountants. Nobody said that. But the effect of what the Court of Appeal was holding, so in effect that was implied just from the circumstances. So that passage is a useful pointer. If we go over the page to 541, and we see an F to G down at the bottom, the judge placed great weight on the fact that a direct statement had been voluntarily made, so he's joining in, as it were. But it does not, and this is where I part company from the judge, follow from the fact that a statement which was made both voluntarily and directly by A to B, that A is assuming responsibility to B. The circumstances in which the statement was made must also be considered to evaluate the significance of the facts of the statement.
So I've lost you completely.
I'm sorry, it's an F to G. I'm gabbling because I'm reading. I'm sorry. It's fine.
Plain from the passage, that
Yeah.
bit?
Yes.
Yes, plain from the passage. The judge placed great weight on
Yeah,
the fact
okay.
it was voluntary and direct, and he said, well, that's not enough. It's all about the terms in which it's made. And then if we go over one more page to 542, and this is perhaps most relevant for current inquiry, there's at letter D, there's a paragraph that starts, it is helpful to return. Does your lordship say that?
Yeah.
And we're going to look at actually, because the checklist in McNaughton is quoted in NRAM and approved, we'll see that, and is then refined in BCCI, which is where I want to spend more focus. But he says there's a checklist. he says the purpose was to give a warranty to Mr. Slater was the advisor of Mr. Shield, who's the seller, and the other vendors, not some valuer or expert independent of any of the parties, and exercising some independent judgment on whom those on both sides of the transaction might be expected to rely. Now, that is an important passage, but it points out that Mr. Slater had not stepped outside his role as advisor to the seller just by making representation directly to the buyer. And the description that's given there is really what my learned friend has to persuade you is the correct characterisation of Mr. Thornhill. He's got to be viewed as a valuer or expert, independent of the party, giving an independent judgment on whom anybody could be expected to rely, buyer or seller. Now, as I will develop on the IM and the subscription documents, that is just not a conclusion which could possibly be reached on the facts of this case. Of course, the advice wasn't given by Mr. Thornhill to Scots so that they could give a warranty of the tax consequences. They were running a mile from giving a warranty of the tax consequences. So it's not the same purpose as Mr. Slater gave his representation. But the advice was still given by Mr. Thornhill for the benefit of Scots, not so that they could warrant the tax consequences, which of course they didn't want to do, but so that they could safely and honestly tell investors that that was what their understanding of the law was. So this case has some resonance here. We can put away Peach. And we can turn to NRAM, because NRAM is the case which Ashraf says, look, this all funnels into NRAM.
Yeah.
And I can take this relatively quickly, I hope. It's in, because my own friend very helpfully has set out all the facts. It is at tab, I think it's 34.
Which,
34. Authorities 5, tab 34. So, my learned friend explained this to you yesterday perfectly fairly, and I don't want to pick up anything on the facts, which are 1 to 17. Just pick it up at 18, just to note that this is then a summary of, that's on page 1282, paragraph 18. So, the Supreme Court, like Mr. Wilson goes through Headley-Byrne. Paragraph 19 is an important paragraph, my learned friend read to you yesterday, but it's not the sole important paragraph in this judgment, as he tries to suggest. He wants to divorce this from paragraph 23, which we'll come on to. But before we look at the link between them, just note not only the twin test, which we're all now familiar with, but the emphasis on the fact that they are distinct. So you've got to look at it from both sides of the fence. Is it, could the buyer reasonably think that they were being entitled to rely on the seller's advisor? But could they also, and often they will answer each other, but it's not necessarily so, is it reasonably foreseeable to the seller's advisor that the buyer is going to rely on the advice they're being allowed to see? So it's important always to look at it from both those angles. Now, from 20, 21 and 22, the Supreme Court traced some waxing and waning of the fashion of whether assumption of responsibility was in or out, which we don't need for our purposes. But if we pick it up again at 23, he says, more important for present purposes is the reassertion in Carr of the need for a representee to establish that it was reasonable for him to have relied on the representation, and that the representator should reasonably have foreseen that he would do so. So this, what that sentence shows you is that the chain of reasoning here is, right, at 19, I'm saying there are these twin inquiries, and here at 23, I'm picking that thread up again and putting a bit of flesh on the bones about what that means. He's unpacking really at 23 the idea at paragraph 19 about the importance of reasonable reliance. What does reasonable reliance look like? And the first thing he says from Caparo is he picks up Lord Bridge saying, look, the representor has got to know that it's very likely that the representee would rely. And then he picks up Lord Oliver saying a usual condition of liability is that the representor knew that the representee would act on it without independent inquiry. So that then puts some helpful context on what it means reasonably to rely. It's about the likelihood of reliance and the likelihood of independent inquiry. And there's then a specific approval of a part of the McNaughton checklist. We go over the page and we see Lord Wilson picking out for specific approval this passage from Lord Justice Neal about the need for foreseeability of reliance, and says, well, you can read it yourselves, but the passage I particularly draw your attention to is in business transactions conducted at arm's length, it may sometimes be difficult for an advisee to prove.
Do you say, if we go back to the discussion about exclusive reliance, do you say that these passages exclude the possibility of a duty of care arising in circumstances where there is reliance, but it is not exclusive?
No, and that was, if I may say so, a very perceptive question. I don't intend to be sycophantic, even if I am. That is a really interesting. No men's rare.
I think that has just been destroyed.
That passes what I call the creep test.
Good. I'm glad I passed it. No, it is actually a really interesting question, and I think my answer to it ultimately, I mean, it's had various phrases. In my head, it's dual reliance. Can I put it in that way?
Yeah.
You're
Yes.
relying on both. Can it be objectively reasonable under NRAM for a claimant to rely both on the seller's advisor and on their own advice? Now, I think ultimately I've got to say that the motto of the common law is never say never. So I'm not going to say that anybody should try to be categorical about this, and I certainly am not going to be. But I would suggest that in general terms, that will be a rare case. And the reason I say it would be a rare case is because the test is it reasonable to rely without making independent inquiry? And if it's not reasonable to rely without making independent inquiry,
You should rely on the independent
Exactly.
inquiry.
exactly, that strongly suggests that the independent inquiry on an objective assessment, is all objective, was intended to be the sole source of reliance.
I mean, leaping all over the place, and I know you're in the authorities, but we almost have an express finding of actual partial reliance
Yes, on the
in
facts.
paragraph 88.
Well, the distinction that was being drawn at the time was about comfort. I mean, it's kind of, it's one of these nebulous words where essentially you know that, well, it's there. I mean, it's like if you're buying into a company, just buying equities in the market, and you go, okay, do you know what, the accountants are Pricewaterhouse, and I know this guy on the board, and this woman is the finance director, and these people are really good, and I'm going to take comfort from that. That was the point that the judge was making there. We'd had some debate
But
about
then
it.
there was another finding, wasn't there, that he knew that they would use the opinion to assist the investors' advisors to
Exactly.
evaluate the prospects. So,
And that's really important,
Yes.
because that's the purpose, when I come on to purpose.
but if therefore, if on the other hand, dual reliance, one of the two dual reliances is sufficient for that part of the NRAM test, it's made out on the facts here,
No, it's not sufficient for the NRAM test.
but for one part of it. Well, reasonable reliance,
Yes, so
reasonable partial reliance or dual reliance by the investor is one half of the NRAM test. If dual reliance is open, is a gateway through.
I would suggest that the gateway is straight and narrow. And let me try and put it again more clearly than I seem to have done the first time. Which is that the test is it objectively reasonable to rely on this advice that I know is somebody else's advice without independent inquiry? That's the test.
You say.
Well, that's NRAM, that's not...
But when Mr Stewart says no, paragraph 19 says nothing
Oh,
about
I see. So it's
independent
subject to the
inquiry.
independent inquiry point.
So
Yeah,
he
well,
says
there's
that
a lot of
comes in
authority to go
later.
through an independent inquiry, and my respectful submission, that's just not open to challenge. The independent inquiry point is absolutely fundamental in this area. And
Because in Peach, for example, there was no question of
there absolutely was impeached. They had EY,
Yeah.
and the Court of Appeal said, well, you've got to rely on your own advisor. You don't just rely on the other guy's advisor. You've got your own accountants, and we'll go through this in BCCI. There are a lot of cases in which the importance of independence in Caparo, it's all the way through the cases that independent inquiry is a crucial aspect of the reasonableness of reliance. That's where it comes in. Is it reasonable to rely? One of the ways, and possibly the primary way in which you test this, is to say, were you expected to make your own inquiry?
But I mean, it might be said that in these cases, axiomatically there are two sets of advisors, if you like, and therefore there is the potential for, as you put it, dual reliance. But the question is the NRAM test, are the two limbs of the NRAM test satisfied on the facts of this case in circumstances where Mr Thornhill wasn't, the investors rather weren't his clients, and where what you say is that objectively objectively it wasn't foreseeable that they would only rely on his advice rather than taking their own independent advice.
Exactly. And that comes absolutely down to the specifics. I quite agree with that. But I'm just trying to engage with my lady.
So the fact there might have been, as it were, dual reliance, it doesn't actually satisfy the test.
No.
It doesn't satisfy both limbs of it.
No, because what the test resolves itself into is it objectively reasonable to rely on someone else's advisor? And one of the key indications in the cases, and we'll come to this afternoon, about whether that is reasonable, is whether you either could have or should have or were expected to take your own advice. And if so, that goes to negate the reasonableness of reliance. So I began by saying, never say never. Then I said, if it were to be, it would be a rare case. And the reason for it being a rare case is this general point, that you have to satisfy it being reasonable to rely without independent inquiry. And if you take, or should have taken the independent inquiry, that negates the reasonableness of your reliance on the other guy's advisor.
Yeah.
But then in the specifics of this case, which we'll come on to, it's clearly not that rare case, because you're told to get your own tax advice, and then you are required to warrant both that you've taken your own tax advice and that you've only relied on it. And that shuts the gate. There's no question in this case of reasonable dual reliance, because you have to warrant that you've only relied on your own tax advice. And I'm sorry, but straight slightly over 1 o'clock, just before we rise, that this question of reliance for duty purposes is conceptually completely different from factual reliance. So in factual reliance, as the judge held, he was very aware of this difference. He said conceptually it is, in fact terms, you can rely on to, but not in duty terms. I've just turned that out. I'm so sorry to the court staff, but it is worth looking at while we're on the point. It's paragraph, it's the judgment 365. Note, is that right? I'm not sure that's a good reference. 354. as my fallback
354?
reference. Yes, 354. And this engages with here the judge engages with my Lady Justice Carr's question about comfort. But, sorry, just backing up to 352, he says, look, in the factual reliance context, it doesn't have to be the sole cause. It's enough that it was a real and substantial part, cites authority, including Raffheisen, in which he was, of course, counsel, so he knows all about this. And that's fine.
That's the Edgington
That's the
Fitzmaurice
fact.
point. That's the Edgington Fitzmaurice point.
Yes. So you can have dual reliance. And then at in fact, in the factual question, then he teases out this distinction at 354. The difference between the opinion being made available says to provide comfort to the claimant, so that they could be assured that Scott's understanding of the tax position was based on a firm and reasonable foundation, and the opinion being made available in circumstances that gave rise to a duty of care is a critical one in the context of the question of whether duty arises. But once the legal conclusion that Mr. Thornhill owes a duty of care and respectful advice is established, it's not helpful, he says, to draw that distinction again, because you can have dual reliance. So his point there is it's just these are very different types of relying on the advice. I'm sorry to have overrun, but it's an interesting question.
2 o'clock.